everybody. We'll just wait maybe half a minute more and then we'll start our webinar. Okay. Welcome. Hello, everybody. My name is Meg and I work on the membership team here at Bond. We're so pleased to be working with Russell-Cooke Solicitors again, who are hosting this webinar with us. Just wanted to take you through a few housekeeping points. So this session is being recorded and the recording will be available afterwards with other resources. Please ask questions throughout and they'll all be covered in our Q&A session at the end. We'll also be sharing a feedback survey towards the end, so we'd love to hear from you, so please complete that. Thank you again to our partners, Russell-Cooke Solicitors. We're so grateful to have you with us today. Joining us is Sam and Carla from the not-for-profit team, and I'm really happy to hand over to them to you now.
Thanks, Meg, and thanks everyone for joining today. So as Meg said, Sam and I are both employment lawyers, but we advise exclusively NGOs, not-for-profits and charities, and we're part of the charity team at Russell-Cooke. So as you know, today's session is about these changes, some of which have already come into effect, and that will become clear as we go through the slides, and some are coming into effect over the course of the next sort of year or so. There are a lot of changes. These are changes that apply to employment law in England and Wales, Scotland and Northern Ireland. So predominantly, we're talking about your employees who are based in the UK. Sometimes employees based overseas can have UK employment law rights, but as I say, the primary focus is really your UK staff. The aim of today is to give you a kind of overview of what's changing, focusing mainly on the things that are going to impact the majority of NGO employers, spending less time on some of the changes that are a little bit more niche. We'll pause on those areas where we think you might be required to do some additional preparation or make some changes to your, let's say, existing policies and procedures. We'll also pause in areas where we think there's, potentially higher risk or risk exposure, either financially, potentially higher damages for tribunal claims, for instance, or kind of reputational risks. For example, kind of a potential increase in claims, which would then be public, might get media scrutiny, that kind of thing. We will be taking it at quite a clip. I will speak for around 20 minutes. Sam will also speak then for around 20 minutes. And as Meg said, we'll be leaving time for questions. So please type your questions into the Q&A and we'll aim to deal with all of them if possible, or at least as many as we can with a prompt finish at 12. So moving on, a little bit of background about this piece of legislation. It's mainly trying to deliver on policy set out in the Labour Party's May 2024 plan to make work pay. And that was delivering a new deal for working people. And the quote on the right-hand side of the slide there from Keir Starmer is from his victory speech after the last general election. So you can see that this was a kind of central pillar of the current government's kind of manifesto. That said, when the Employment Rights Bill, as it was before the legislation passed, went through Parliament, it was a bit of a bumpy ride and quite a few changes were made, quite significant changes from Labour's original plans. And some were actually new changes that were quite unexpectedly introduced, in some cases very late in the day through the scrutiny process. So it had its first reading in Parliament back in October 2024, and it received royal assent right at the end of last year. So it is already an act of Parliament, but there is this implementation timetable. So the majority of the changes didn't come into effect immediately. There's phased implementations through what we call secondary legislation, so regulations that are being made. And alongside that, numerous consultations. I mean, as employment lawyers, I think an exhausting amount of consultations. It seems like every week there's 2 or 3 new consultations starting. So if as we go through, you think there are specific topics or areas that are really going to impact on your organisation and the way that you engage staff, there may well be an opportunity for you to input on consultations in those areas before the final kind of detail that will kind of flesh out what the bare legislation says comes into effect. Um, After today's webinar, Bond will be sending you out a copy of these slides, and we'll also include a couple of links to resources where you can get more information about some of the things we're talking about, as well as the things we won't be able to cover today, and where you'll be able to keep up to date on things as they change and progress and as things come into force. So it is going to be quite a dense session today. We are going to be looking at zero, low hours and agency worker changes, harassment and whistleblowing, and there is a connection there which we'll make clear. Trade union changes as they affect or are likely to affect the people on this webinar. There are actually a whole host of additional changes, but they're quite technical and really mainly for the unions to kind of get their heads around. So we won't touch on those. Changes to sick pay and family leave and pay, changing contract terms, often what's kind of badged fire and rehire, but actually the changes in the Act go quite a bit further than just really talking about fire and rehire situations. Changes to redundancy, specifically around collective consultation, so where you're proposing to make 20 or more people redundant within a certain time period, and unfair dismissal and employment tribunal claims changes. So there's a lot to get through in our 40 minutes. That said, there's lots that we're not going to be able to touch on today. So you should be aware that the legislation does also include a whole range of other things, including establishing social care negotiating bodies, changes to umbrella company law, working time records, tips and gratuities, restrictions on the use of NDA, non-disclosure agreements in certain circumstances, rules around time off for public duties, specific provisions for the public sector and for seafarers, if anyone works in that area, and the establishment of a new Fair Work Agency, which is a kind of enforcement body bringing together a couple of different current government bodies. So if any of those things that I've just whizzed through are things where you think, oh, I really do need to know about that, then again, those links that we're going to share will be the resources for you to go to in the first instance and have a look. But because they're a little bit more niche and not quite so impactful, we're not going to be looking at those today. So moving swiftly on. The first topic, as I said, is looking at changes to current arrangements for people on 0 hours contracts, or what are now called low hours contracts, and changes to agency worker engagements sort of connected to that. As the slide says, these are expected to come into force next year, so still a little bit of time to consider how these might affect your workforce and, if necessary, to make changes or at least prepare for changes to how you engage or, workers and employees if you use these kinds of casual worker arrangements. These are some of the more complex parts of the legislation. And even though the Act itself has pages and pages on this, there's still going to be yet more detail in regulations which haven't yet been published. So a lot of the devil here will be in the detail, and we just don't quite know it yet. So it's an area to watch if this is a way that you engage people. One of the key things is this new duty to offer people guaranteed hours if they work regularly over a reference period. So typical situation, they're engaged on ostensibly a 0 hours contract, but actually the individual works quite regularly, say 10, 20 hours a week over a reference period. That will give them a right to be offered a contract with that guaranteed amount of hours. Now, you can see the public policy reason for this, and it's meant to stop exploitation of 0 hours workers. But from an employer perspective, it's going to be quite onerous. So the first thing we don't know yet is what this reference period is going to be. So there's a consultation paper out, and that suggests a reference period of 12 weeks. But there are other kind of groups, employer business groups, and predominantly, who are pushing for a much longer reference period, 6 months or even 1 year. The reason why they're pushing for that longer period is really practicality. This isn't a one-time thing. It's not like the agency worker regs where after 12 weeks people get certain rights. This is an ongoing rolling duty. So you're going to need to keep monitoring whether people on these arrangements have worked regularly over a rolling reference period. And you'll need to then be ready to offer them this guaranteed hours contract if they kind of trigger that right. So, so really quite a significant administrative burden if that reference period is every 12 weeks. Um, there's another kind of interesting, let's say, quirk, which is where we're talking about agency workers in this situation. The right is that the hirer, so that's you, the charity NGO who's using an agency worker, it's the requirement for that hirer to offer the guaranteed hours contract. Now, for anyone who uses agency workers, you know well that the agency contracts will almost always have a kind of non-poach clause in them, saying you're not allowed to try and take our agency workers and encourage them to become your own employees. So this really cuts across that. And it's really unclear quite how agencies are going to deal with that, because clearly for them, this is really impacting on their business model. If people who are working over this reference period are kind of essentially by law poached by the client. Again, it depends on the reference period, but if the government does go ahead with its 12-week proposed reference period, I think that could make a really big difference to how and when organisations use agency workers, and perhaps for anything other than a very short period of cover, sort of a month or two. I can only imagine that this is going to make the use of agency workers kind of null and void, really. So we'll see what happens there. And I should make clear that there is absolutely no obligation on the worker to accept this offer of a guaranteed hours contract. So if you do have people who actually want to be on a completely flexible, completely casual 0 hours contract because it fits with their other arrangements, then they can just say no to the guaranteed hours contract, and that's fine. You're not breaking the law. But you need to, the duty is to offer them the contract. There are also two other duties which I'm not going to go into so much detail on because they're a bit more simple. Duty to provide reasonable notice of shifts. Again, we don't yet know what reasonable notice is going to be, but the suggestion is something around a week. And that means not just giving notice to the shifts in the first instance, but telling the employee or the worker if those shifts change at short notice. And equally, then compensation if the shift is cancelled, moved, or curtailed, again at short notice. Just touching on agency workers, that final point, if the compensation is payable and it's an agency worker, then the duty to pay the compensation falls on the agency. Again, I can only imagine agencies are going to try and pass that cost on to you as the client. So it will be a commercial point to watch out for if you're using agency workers in the future. So harassment, breaking really and moving on to a completely new topic. This one is expected in October this year, so not very long ago, not very long away at all. It's really similar to the existing duty to take reasonable steps to prevent sexual harassment in the workplace, but there's a kind of upping of the ante to take all reasonable steps. For anyone who was watching closely, when the legislation that introduced the duty to take reasonable steps, i.e. the one that's already in force right now, was going through Parliament, the original proposal was for it to be this, to take all reasonable steps. And at that point, there were concerns expressed that was too high a burden, too high a bar to put on employers. But it's kind of snuck back in through the back door through the Employment Rights Act 2025. So this is a duty to prevent harassment by a third party. If the harassment happens in the course of employment and if the employer failed to take all reasonable steps to prevent the harassment, then the employer can be liable. Now, third party here basically just means anyone other than you as the employer or one of your employers. So depending on the work that you do, that can include service users, clients, customers, contractors, people from other organizations, partner organizations that you work with. The penalty for non-compliance is an uplift to compensation in a claim by one of your employees, and the EHRC also has the power to investigate where there's a failure by an employer to protect staff to the required level, and they can take enforcement action as well. There used to be a similar duty to this in the Equality Act, which was actually repealed back in 2013. If anyone remembers that, the kind of bad news, I suppose, is that this new and very similar obligation is actually more onerous than the old one. So the old one used to require the harassment to have happened on at least 2 occasions and for the employer to have had knowledge of the harassment. Actually, neither of those is required anymore. It is simply that it's a proactive duty for you to take all reasonable steps and then to react if a complaint is raised in an appropriate way. So I think you can see this is going to be particularly risky for any of you that work in sectors where your staff are frequently coming into kind of direct contact with third parties, whether that's face to face, on the phone, online. So, if you're operating something like drop-in centres or clinics or something, you can see probably you're going to need to be really focusing on what you need to do here. The question of exactly what you do need to do, unfortunately, is still one of those we're not quite sure. There is a government fact sheet published on what they think will constitute all reasonable steps. And helpfully, it does suggest that it's going to depend on the specific circumstances of the employer, including your size, the sector you work in, your working environment, and your resources. So it will be proportionate to all of those factors. But we're waiting for regulations to be made to say what exactly all reasonable steps means. Now, as you might know, the current duty to take reasonable steps, not all, but just reasonable, is supported by EHRC guidance, where there's an 8-step guide that they've published. And that already includes having policies, training staff, doing risk assessments, monitoring, evaluation, responding to complaints, etc. So we're just not really clear exactly how much of an increased burden this will be. But certainly, I think it is something to really watch out for and make sure you're ready for if you are operating in those kind of frontline sort of sectors. Connected to this, perhaps unexpectedly, is changes to whistleblowing that are actually already enforced. So already enforced from April this year. It's a kind of relatively simple change in some ways. The definition of a qualifying disclosure, so a kind of something that counts as whistleblowing, now specifically includes a disclosure that sexual harassment has occurred, is likely to occur, or is occurring. It is still necessary for the worker who makes that disclosure to satisfy all of the other requirements for it to be a protected or qualifying disclosure. So it needs to be, they need to have a reasonable belief in it, it needs to be made in the public interest, etc. Just remember that disclosures can be made to you as the employer or to prescribed persons or legal advisors. So that could be to the Charity Commission, for example, if you're a registered charity. Wider disclosures, for example, kind of to the press or on social media, are sort of less likely to be protected, and there would be limited circumstances in which that would get someone protection. If an employee is subject to any kind of detriment by you as the employer as a result of making a disclosure that they believe sexual harassment has occurred, is occurring, or is likely to occur, then they get that protection and protection from unfair dismissal as well if their employment is terminated. One thing to mention, because it's actually come up a lot recently, is this possibility of interim relief, which is a kind of damages, really, I suppose, or obligation for you to make payments, which only applies in very limited situations, and whistleblowing is one of them. So it's basically an ability for an employee who believes that they have been dismissed unfairly because of whistleblowing, so because they reported sexual harassment, to go to the tribunal within a week of putting in their claim form and say, the employer should continue to pay my wages right up until the final hearing because I'm likely to succeed. And that can be really expensive because for anyone who's dealing with tribunal claims at the moment, final hearings are being listed a year, 18 months, sometimes 2+ years in advance. So I think that's one of the big changes, like the practical impacts that this could have, that bringing sexual harassment squarely within the whistleblowing context, can give people these additional protections and additional potential routes to compensation. I mean, some people are kind of like, is it really a change? Arguably, sexual harassment was already a breach of a legal obligation, and so already came within the whistleblowing legislation. But I do think this change, having it sort of set out in black and white, will encourage people to make reports and to feel more confident that they're protected from, detriment. Particularly, a lot of these kinds of cases, particularly if it's sexual harassment in the workplace, can involve imbalances of power. It can be really difficult for a junior employee to come forward and speak out about this kind of thing when it involves someone more senior who has influence over things like, promotions, pay, etc. I've put at the bottom of this slide the action points that we suggest you take now. So update your whistleblowing policy to make clear that disclosure of sexual harassment is now a qualifying disclosure, and ensure that your managers and HR team know that if they receive sexual harassment complaints, this is going to fall within the scope of those policies, and people do get those additional protections. I'm going to spend a little bit less time on this because I think it's mainly something for you to kind of just be aware of. But unless you happen to be going through a process at the moment where a trade union is seeking voluntary recognition with you, it's not going to be directly relevant. These changes are expected in October this year, but we have seen a number of requests being made to not-for-profits, NGOs and charities in the last year or so from trade unions asking for a recognition agreement, a voluntary recognition agreement in the first instance. And there's been a real uptick in the last few months. And it might be because of these changes. So there's already a simplified procedure for requesting recognition that's in force. And when these changes come into effect, there's going to be a number of additional rights. So a right for employees to be given a statement of trade union rights that you, the employer, need to give them at the outset. Again, I feel like a bit of a broken record. Regulations will tell us exactly how much information is required and what you're required to and what information you're required to give. But it's obviously meant to inform the employees at the outset they have the right to join a union, and to make clear that the employer isn't going to kind of see that as a black mark against their name. Unions are also going to have new and increased rights to access workplaces, and there are these new concepts of access agreements that will apply to employers who have 21 or more employees. And that's going to give the unions the right to enter into these agreements to give them access to your work sites, possibly also online meetings for various purposes. They can't use it to organize a strike, but otherwise they can use it, to meet with employees for all kinds of usual trade union business. These access agreements can give them one-off access, but I think it's probably more likely that they'll be used to give them regular access. So we'll see how much those might be used and what the regulations say about what they can ask for. And then additional protection for employees against detriment for taking industrial action. Again, TBC, what exactly that detriment might include. But for a long time, there's been a little bit of lack of clarity as to whether an employer can deduct people's pay if they take part in strike action. And in my experience, it's quite common for organisations to do that right now. So it's a wait and see, but we think there might be a new regulations saying that if you do that, if you dock pay because someone is taking part in organised strike action, that could count as a detriment, and they could have a claim. But as I say, we need to wait and see. So final slide from me before I hand over to Sam. Changes to statutory sick pay. Again, these are already in force, so you may well already be aware of them, but I think it's worth making sure that you're on top of them. So SSP, statutory sick pay, is now payable from day one of someone's sickness absence. There used to be this 3-day waiting period before someone got SSP. That's gone. As is the lower earnings limit for someone to be eligible for SSP. That's removed. Everyone is eligible. Instead, there's a cap on the weekly rate of SSP. It's either the prescribed rate or 80% of the employee's normal weekly earnings. That has thrown up a slight oddity for some employees. If you earn a certain amount, you'll actually be slightly worse off than you were before. But the government knows that, and they've just said they're willing to accept that as a benefit of removing the 3-day waiting period, meaning that everyone gets SSP from day one. So just final point, obviously updating your sick pay policies if you haven't already, and making sure your HR systems are updated so that people are getting that SSP from day one. Okay, and I'm going to hand over to Sam now. Sam, I can't hear you. I don't know if...
Oh, can you hear me now?
Yes.
Great. Yes, I'll be kicking off my section talking about the family leave provisions. Some of those are already in place from April 2026. Some of them will be coming in soon. So this first slide is talking about those which are coming in from April 2026, so already in place. The first is day one parental leave. Previously, there were some requirements around certain lengths of service in order to be entitled to this. This is now in place from day one. It's the same with paternity leave, which again previously was there was a requirement to be employed for 26 weeks. Again, this is now in place from day one and means that all employees will be able to claim that from as soon as they're employed under their employment. And there is a slight quirk which has been added in respect of the paternity leave provisions, and that effectively is stating that where there's a sort of crossover between shared parental leave and paternity leave, employees are able to effectively claim both. Previously, there was a slight quirk where if you used paternity leave, or use shared parental leave, that would counteract your ability to also claim paternity pay and paternity leave, but that's now been resolved. So employees are able to effectively rely on both of those. Moving on then to the ones which are coming next. And again, as Carla mentioned there on the slide, the action point for those two is, of course, to check your current family leave policies and make sure they're all compliant as well. Coming in 2027, we have bereavement leave. So this is an existing right to 2 weeks in certain limited circumstances, and in a similar vein to a lot of Carla's changes that she talked about so far, the detail is to be confirmed in the regulations, which will be coming in due course. We then have a strengthened protection around against dismissal for employees who are pregnant or have been pregnant. So this will mean, again, subject to regulations and to the consultation processes which are ongoing, but it looks like from what we've seen so far that this could include making it automatically unfair to dismiss an employee who has been basically returned to work since pregnancy, and in that period for 6 months after they return, that it will be automatically unfair to dismiss them during that period. So that's one potential change that we could see. And there'll also be some strengthened protection around dismissal for employees who are taking or returning from a period of statutory family leave. Again, it's not entirely clear what this looks like at this stage, but there's a good chance that that will sort of include similar provisions against detriment for taking that statutory family leave. Then moving on, so this is the point that Carla mentioned earlier, which is the sort of points around fire and rehire and changing employment contract terms. And these are proposed to come in January 2027. And I think this is one of the key changes in the provisions. And when there's been a lot of talk amongst employment lawyers about whether this is even a workable change as it's currently drafted. We attended a conference recently amongst employment lawyers where there was some discussion about whether it just won't come in at all. But as it stands, this looks like what it'll be in January 2027. So there's been a lot of changes from the original proposals put forward under the bill and as part of the parliamentary discussion following that. But the main point is that it introduces a concept of something called a restricted variation. And what that means is for those points listed there, so on the slide, changes to pensions or pay, hours and working time, holiday and time off, and anything else the Secretary of State specifies, which is, of course, lovely and broad, it will be automatically unfair to force employees to accept these changes through fire and rehire. So that's a huge sweeping change, which means that it's very, very difficult, or much, much more difficult to apply these fire and rehire type approach to contract changes. There is a very, very fine exemption which applies where the particular organization is in dire straits financially, so effectively on the brink of closing down. That would allow you to make these changes without it being automatically unfair. But as far as we can see from the information we have at this stage, it's pretty limited in its application, so it would need to be a serious point. a few points to note in respect of that. So when we talk about employment contract terms, that doesn't necessarily only relate to those express terms within the employee's contract. It could also include implied terms, and that could include things like, whether it's different agreements related in writing, which have been put in emails between employees and the organization, or alternatively just agreed verbally or as part of policies. So it's really broad. It doesn't necessarily limit itself solely to the terms of the contract, but also could apply to various other arrangements outside of the contract. So one way that could be dealt with, and as far as we can see, one option open to employers would be to add a new variation clause into their contracts before this legislation is sort of put into action in January 2027. Now, the government's thought about this from January 2027, and they've said that adding a new variation clause after that date would amount to a restricted variation. So you can kind of see they've closed off a possible loophole of allowing employers to make changes after that date. But so far as we can see, there's nothing to stop you from adding that sort of arrangement in now, so you can make those changes in due course. There are a few other points to note in this as well. So outsourcing, a restricted variation includes where the employer dismisses so that they can employ another person or re-engage the same person on different terms to carry out the same or substantially the same duties. So as you can see, this isn't quite as simple as saying that it's much more difficult to fire and rehire, but it's also preventing a lot of the sort of freedoms that employers have now to sort of make contractual changes to terms. And for the avoidance of doubt on this section as well, it doesn't matter if the changes are agreed via a trade union. If a particular individual employee refuses the changes to any of these points, it would likely be automatically unfair. So it's a real change to how these contract terms are amended in practice. Moving on to the next slide, it's also the case that terms outside of those restricted changes are also going to be affected by this. So whilst you may try and make changes to an employee's contract terms, if it's outside of that restricted change point, it won't be automatically unfair, but there's still an opportunity for the employee to argue that it is unfair. And then any tribunal would then have to consider as part of those points whether it's unfair for you to make that change. Now, there's a number of fairness factors, again, which are subject to regulations that we haven't yet seen. But the overriding point there, I suppose, is that any contract changes will be under a lot greater scrutiny under these provisions than they would have been previously. So there, again, as you'll see, there's a number of action points on this, all of which are quite time sensitive, considering that these changes are coming in relatively soon. The first is to audit the contracts and policies that you have with your staff as at the moment, and that would be important to consider which of those terms are part of the employee's contract terms and which are just non-contractual policies. And that differentiation between the two is very important for the purposes if you want to change terms going forward. It's important to establish which ones will be contractual terms and which ones won't be. There are a couple of options which can also be implemented into the contract, which clauses can allow some flexibility. The first is what was one I mentioned already, which is a flexibility clause, which will allow you to make minor changes and specify certain changes in contracts which you'd like to be able to flexibly change. That can be put in place now as part of before the act is put in place in full. The second is a no oral variation clause, which effectively will allow you to say that to employees that any oral discussions with them wouldn't allow them to argue that that is now an express contractual term of their employment. So it limits the contractual terms to those agreed in writing with them. And that links in with the entire agreement clause, which is the third one mentioned on the slide there, which is effectively stating that the written terms of your contract represent the entire agreement with the employer, and there's no other oral changes that can form part of that entire agreement. All of those can now, as it stands, start to be put into contracts of employment to try and limit the impact of these changes. Thirdly, it's to bring forward plans to amend restricted contract terms to now. So, of course, as it stands, these changes aren't in place yet. So January 2027 is the deadline. So if you do have plans to make pretty significant changes to any of your employees' contract terms, now is the time to sort of get action on that and start taking some steps. And lastly, it's to give the managers in your organizations some training on how these changes are taking place. It will no longer be as easy as making amendments to employees' contract terms in the same way as we've done before. It will be much more difficult. So it's important that everyone in the organization is aware of that. Great. Moving on to collective redundancies. So this is, again, quite a key change in the legislation, and this is expected to come in 2027 as well. The first of the major changes is that the protective award for collective consultation is being increased from 90 days pay to 180 days pay, which means it's very, very important for organizations to ensure they're aware of when collective consultation requirements will apply. Because of course, each of these, this 180 days pay would apply in respect of every employee that was part of the consultation process. So it's a huge increase, a double increase in the potential compensation. There are also changes to the threshold for collective consultation. As it stands, under the current legislation, it's 20 proposed redundancies in a 90-day rolling period at one establishment. And again, as Carla's slide states there, this is subject to more consultation and within the regulations, which will come in due course. There are a number of discussions about how that threshold number will change, one of which is the removal of the establishment wording, which currently applies, which allows organizations to say that each individual site of an employer's business has its own separate counter for collective consultation. One of the proposals is to make that an organization-wide threshold, which will mean that, of course, many more organizations will be dragged into this requirement to collectively consult. Again, that's not in place yet, but it's one of the potential outcomes of the collective consultation process. So there are a number of action points on this one too. The first is to review policies and to train managers and HR to be able to track when the threshold for redundancies is for collective consultation is met. Again, we always see, well, very regularly see this discussion around the rolling 90-day period, which is quite tricky to keep track of. And that's particularly the case where you have a multi-site employer. So it would be important to start putting systems in place that allow you to track whether or not that threshold has been met, particularly if you're operating over a number of different sites. And the third option there is consider introducing some sort of standing employee consultation body for collective consultation. Now, might be the case, particularly if you're envisaging that there's going to be a number of these type of processes over a period of time, rather than electing an entirely new consultation body on each occasion. It might be more helpful just to have one body in place, which you can apply in every situation going forward. Moving on to the next slide. This is unfair dismissal changes, which will, as far as we're aware, they'll be expected to come into force on the 1st of January 2027. And this is a really crucial change for a lot of employers, and it's crucial for definitely the employment tribunal processes that we see regularly. The first major change is that the qualifying period to bring claims of unfair dismissal in the employment tribunal is being reduced from 2 years to 6 months. So that means that employees, a huge number of employees, are going to be able to claim unfair dismissal, whereas under the current arrangements, they need to be employed for a continuous period of 2 years. The second major change is that the statutory cap on compensation is being removed. And as it stands, compensation for unfair dismissal is limited to the lower of either 1 year's salary of that particular employee or a statutory threshold of around 123,000. That cap is being removed altogether from the 1st of January 2027. So, I mean, the government estimates that reducing the qualifying period from 2 years to 6 months will protect a further around 6 million employees from unfair dismissal. And that will generate an additional 9,000 ACAS early conciliation referrals. And about 3,000 of those will progress to a tribunal claim, and 570 of those will require judicial time. And as Carla mentioned earlier, we've already seen a huge uptick in the number of tribunal claims, of which many are increasingly complex and take up a considerable amount of time to deal with. So we're seeing most common claims already, taking 2 to 3 years to resolve from start to finish. There's a question here around, of course, the Labour government's ideas around the introduction of this is to, of course, increase access to justice and the ability for employees to assert their rights. But that is sort of thrown into question when you consider the length of time that employees are going to have to wait to bring these claims. So it's certainly a point to keep in mind, particularly from a charity's perspective, if you're going to have to potentially be on the hook for a claim over a long period of time if the settlement isn't reached over the course of the first few years. There is an argument, of course, that employees being able to bring an unfair dismissal claim will prevent them or maybe incentivize them not to introduce such complex claims that we've seen recently. So a classic example would be to introduce discrimination as a potential claim on top of an unfair dismissal claim, or something to do with whistleblowing, in order to navigate the 2-year threshold. It's possible, but I think based on our discussions and what we think and what we've seen internally, AI is increasingly used by employees in these sort of disputes, and we think it's unlikely that their complaints will become any less complex as a result of these changes. So with those 2 points in mind, the action points here are first to review probationary periods, and that's particularly the case if the probationary period currently sits at 6 months. So because the qualifying period has been reduced to 6 months, it's important to have at least a few weeks threshold between the end of a probationary period and that 6 months to allow you to dismiss if during that period, without straying into an unfair dismissal right territory. The second point is to train managers to effectively assess performance in those first few months. It's obviously now more crucial than ever to ensure that managers can observe a new employee's position within the organization in the first few months and make a valued sort of judgment call on whether or not their performance is going to be correct. Of course, if they don't do that in the first 6 months, the employer would have the right to bring a claim for unfair dismissal. So there's a need, therefore, to follow a fair process and to have a fair reason, which takes up a considerable amount more time to deal with. So it's really important to have that in place and organized within the first few months of employment. Then moving on to tribunal time limits, which is the final slide. This is expected to come into force in October 2026, so this is sooner rather than later. The current position is that employees have 3 months from the date of the last act of discrimination or the effective date of termination to bring a claim. This is going to increase from 3 to 6 months. So they'll have more opportunity after a dismissal or after a dispute to bring a claim in the tribunal. This, of course, from a charity's perspective, there's more uncertainty for the charities as to whether, after taking action such as dismissal, there will be a claim in the post in due course and whether that will follow through. On the other hand, I suppose it does extend that possibility to have more discussions about settlement before the claim is actually submitted as well. So there's potential for more discussions at that point. But it is likely that this will increase the amount of claims that employers will need to deal with too. I think that's the end of my section.
Thanks, Sam. I'm going to stop sharing the slides now so that we can have a look at the questions that have come in. And obviously, if anybody else has any questions, please type them into the Q&A and we'll come on to them. So, I think before we start on the questions, I think as a general comment, you can kind of start to get a picture of how these changes, in and of themselves are each quite significant. But when you consider the kind of overlap and interplay between them, the bigger picture is that there's quite a lot more of an administrative burden on employers. And if you get it wrong, the potential penalties, costs, etc., can be quite a bit more damaging, both financially and potentially reputationally. So one of the first questions that I'm going to take is about how this all applies really to smaller charities, smaller employers with limited funds and limited resources. And I think, the short answer is that there isn't going to be a kind of a blanket separate route for smaller employers. It's a lot, and as currently is the case, everyone is expected to comply. I mentioned a couple of areas such as the all reasonable steps requirement in relation to sexual harassment, where the indication, and you'd expect it to be the case, is that there will be some kind of proportionality depending on the size of your organization, the type of work you do, etc. I think there'll need to be a recognition that some organizations, and I imagine quite a few of the people who are on joining us today, will be in the situation where the activities that you do are just like more towards the higher risk end. So that will be taken into account. But really, the sort of long and short of it is that all employees will have these rights and all employers will be expected to be ready and to comply. So Taking first a question that is a relatively simple one, which is about the changes we talked about in relation to harassment, and I've just mentioned that kind of duty, the enhanced duty to take all reasonable steps. And yes, to confirm, that is only in relation to sexual harassment of by third parties. So that is currently the case, and all that's changing is that you're going to have to take all reasonable steps. So yeah, as I say, there is a minimum question about whether virtual assistants class as agency workers. That's actually just a kind of practical question, really, for you to understand how your VAs are engaged. So an agency situation is where you're using an interim third party, an agency, a work provider to give you that employee. It's not to be confused with personal service companies. So sometimes consultants, self-employed consultants work through their own company. So like I might have Carla Whalen Limited and work through that. That's not an agency for legal purposes. Equally, there can be situations where somebody works via an umbrella company. And I did mention at the start that actually there are some changes to the umbrella company model. So if you yourself do any work through an umbrella company, you'd need to get on top of that, but they wouldn't be classed as agency workers. So I definitely think if your organization is using people who are engaged through some sort of third party intermediary, it would be a good idea now to get on top of whether they would be classed as agency workers. It's already important because there are regulations that apply to agency workers that you'd need to be complying with, but it'll be even more important when those the requirement to give guaranteed hours contracts or to offer guaranteed hours contracts come into place. As expected, a couple of questions about the point Sam was talking about in relation to making changes to contracts. One of the questions Gemma asked was about how those changes would affect people who are on multiple short-term and part-time contracts for one organisation. So those particular changes around restricted, changes and the right to claim automatic unfair dismissal, they don't really. It doesn't really make any difference whether someone's on a short-term contract or a permanent contract, or whether someone's on multiple contracts with the same employer. You really just look at each contract and ask yourself, is the employer trying to make a restricted change in relation to each contract? So that in itself, won't make a difference whether someone's on one contract or has 3 contracts. The rules will apply to each contract. I suppose it just might add complexity if you've got more contracts to keep track of, and especially if you're in a kind of organization where it's not too uncommon for managers to just agree a change through emails. I think that's really what organizations have to kind of stop, really, because it's going to become so much more risky, and you need to keep on top of exactly what the contract terms are. And that comes on to kind of Gemma's second question, which is a really good one, about Sam's point about how it might spread beyond what's just written in the contract. So the short answer is, if you've got policies and procedures that say these are non-contractual, they don't form part of the employment contract, then we wouldn't expect a tribunal to say they suddenly do. I think it's more about those policies and procedures, whether it's silent and it's not clear. And I think it's also those kinds of grey area things. So that go back to my point about management send out an email or a memo which says you'll be getting this bonus payment, or you'll be able to take an additional day off or something. Those are the kinds of things that are more likely to have contractual force in the future. And so I think you'd really want to put a lid on that. I think the impression that we're getting is employers are likely, if these changes do come into effect in the way that is currently proposed, employers are likely to be issuing more contracts. So at the moment, I think it's fair to say employers don't tend to issue new contracts when someone gets a pay rise each year. At most, they might issue a formal letter of variation. Actually, most of the time, in my experience, just doesn't happen. The pay rise just takes effect, and you look back at the contract that the person was given 5 years ago, and it says your salary is, a lot lower than what it actually is in practice. I think with these changes, we're going to see a lot more kind of reissuing of contracts. So that it's really, really, really clear. There can be no question about what is in the contract. And coupled with what Sam said, we haven't traditionally had those more commercial contract terms in employment contracts saying explicitly, this is the entire agreement between the parties, no other oral or written agreements will have contractual force. We don't tend to see that. But I think with these in mind, and given the risks, it would be sensible to have that in your contracts and to issue refreshed contracts with that wording in before the 1st of January. Similarly, something saying, even if a manager has said something oral to you and it looks or sounds to you like it's contractual, if it is not written in this contract, it will not have contractual force. It won't vary the terms in this contract. So if your contract says you're not entitled to carry over holiday from 1 year to the next, and a manager says to someone, actually, it's fine, you can carry over 5 days, that won't be a contractual change. And if you wanted to crack down on that practice creeping in, you wouldn't be making a restricted change by going back to what was written in the contract. So I think it's more, a lot of it is going to be, if these changes do come into effect in this way, it's going to be changes in the kind of practice, and frankly, is going to make employment contracts a lot more kind of commercial in nature, and the actual, I don't know if Sam would agree, but I think a lot of the time we almost see people being quite relaxed about employment contracts. Maybe they're not even signed. Maybe, quite often we'll be asked to do, say, a settlement agreement or something at the end of someone's employment. This person's been working for the organization for 8 years, 10 years. And we say, can we see their contract? And the employer's like, oh, don't really know what that is. Do we even have it? Oh, we've got a document. It was never signed, but actually it doesn't bear any resemblance to what this person now does. I think if that was like more of a commercial arrangement, it would be much more unusual to say, we have a service provider, but we just didn't agree a contract with them, or we never got them to sign the contract. So I think it's that kind of mindset change, that the contract documentation and how it's written, and making sure that it's updated every time a change is made that's contractual will be important. More admin, more admin. Are there any other questions? And there is a question, Fatma. Yes, the recording is going to be shared. Oh, actually, I'm not actually sure about the slides will be shared. I believe the recording is also going to be available as well. And yeah, just had confirmation. Yes, the recording will be available as well as the slides. And with the slides, there'll also be a link to a couple of resources that you can go to, reliable resources, where you can find more information about what we've been talking about and keep track of changes as they happen. There is one more question, and we do have 5 minutes or so still, so happy to take any more questions. This question is, if a charity has limited HR capacity and is undertaking a policy review program, which employment policies would we prioritise first from a legal risk and tribunal risk perspective? I'm going to have a pop first and then invite Sam to come in. If he's got any other thoughts. I suppose, being pragmatic about it, the ones that might cost you money. So policies that give people rights to particular pay, if you've got sort of something that is supposed to be like a discretionary bonus scheme or a discretionary additional time off kind of policy, and it's all a bit unclear, and maybe there's been custom and practice over the years of regularly giving payments or, as I say, sort of benefits of some sort, then those are the ones to start with. So policies that deal with things like dignity at work or something, they're very important policies, but they're not going to give rise to a claim for a contractual right to pay or to a benefit. So yeah, really, thanks, Vina. Yeah, really making sure you start with those ones where somebody could take the policy and say, this gives me a right to a payment or something like a benefit, whether it's a bonus or time off. I don't know, Sam, if you had any other thoughts. Oh, you've gone silent again.
Yeah,
I think it's because
completely
our
agree.
headphones keep
Yeah, I
muting.
don't know what's going on. Anyway, yeah, I completely agree with that. And I think, yes, particularly those changes around family leave and sick pay and those sort of things, those changes that have come in as part of the Employment Rights Act. Again, it's important to keep those and make sure they're up to date with those changes. I suppose there are legal requirements around disciplinary and grievance policies, which are always helpful to have in place. ACAS does have guidance on that as well, which can be quite helpful to look at if you're, confirming which policies are really essential. So yeah.
Great. Are there any other questions? Let's just have a look. What's the recommendation about developing training on this, given the phased implementation timetable and ongoing consultation? Yeah, I mean, there's no doubt it is really challenging. I mean, it's challenging for us as advisors. This isn't an ideal kind of message to be having to communicate to you, which is like big risky things are coming. They're going to require you to take a lot of steps. We don't know what steps yet, and that's not lost on anybody. And I would like to think it is not lost on the employment tribunals when it comes to kind of, looking at how quickly you can actually get on top of these things and get to grips with them. Again, I think as we've gone through, there are certain things that carry a slightly higher risk than others. So anything relating now to unfair dismissal or automatically unfair dismissal, those final slides that Sam talked about, where the compensation for unfair dismissal is uncapped. So again, if any of you are kind of regularly involved in managing kind of internal employment disputes, HR matters, you may well have got used to or comfortable with kind of assessing risk almost into kind of boxes. One where you've got someone who just has kind of what we might call ordinary rights, unfair dismissal, contract rights, and one where people have additional rights, particularly in relation to discrimination, protected characteristics, maybe long-term illnesses or long-term conditions that would give them protection as under the disability provisions. And we talk about the risks separately because currently an employee needs 2 years service to even bring an unfair dismissal claim. And if they do, we know we can quantify the maximum financial exposure because of that cap. Whereas discrimination claims are uncapped and they can be much more valuable. That distinction will go. So anyone who has 6 months service and can bring an unfair dismissal claim, the financial exposure is potentially not too different to a discrimination claim. They won't get those injury to feelings awards, but the compensation they can get if they're going to be out of work for a long time as a result of the dismissal. Maybe they are someone who is nearing the end of their career, so it's going to be really hard for them to find a new job, particularly a new job at that level, or where there's pension kind of losses. No cap on that compensation. So you're going to have to kind of make changes to how you assess risk where somebody could claim unfair dismissal. And that's really where it links back into that point about changing contract terms. So I think I would say back to the question really, is start by training senior managers, people who would be actually making these decisions, dealing with these complaints, putting through contract changes, to at least give them the warning, the headline points. These things are changing. If in the next few months, particularly, after January, you're planning or thinking about making these kinds of changes, come to whoever it is, HR, ops director, CEO, come to them first to make sure we're clear what the law is at that point. And then I think, frankly, rolling out training to the wider staff will have to wait until we know the detail, because otherwise it's going to be too confusing for them. Okay, I promised we'd finish promptly at 12, so I think 1 minute to 12. I will end there. Thank you all for attending.